Have you ever felt that? That feeling when a massive public outcry, that huge wave of digital outrage, just seems to carry more weight than the actual verifiable facts in a case.
It's a powerful force.
It is. And today we are doing a deep dive into some incredibly challenging source material. We're going to unpack the really rigorous evidence-based arguments from scientific analyst Justin Lake.
And this isn't comfortable reading. It's not supposed to be.
No, not at all. Because Lake uses logic and some really hard data to critique the very mechanism of our justice system, especially when it comes under that kind of intense emotional or social pressure.
That's the critical point to get right from the start. Lake is not just, engaging in some purely philosophical debate about ethics.
Right, it's not an academic exercise.
Not at all. He is connecting philosophical failure, this erosion of bedrock principles like due process and the presumption of innocence.
Yeah.
He's connecting that directly to systemic measurable failure.
And he's got the proof.
He uses the staggering empirical proof of recent exonerations to back up his central claim that our institutions, and sometimes society as a whole, they often prioritize the appearance of justice over the actual, execution of justice based on proof.
The optics. It's all about the optics.
It's moral signaling. And he argues it's become more important than the truth.
Okay, let's unpack this then. What happens when good intentions become a tool for moral policing? Because that's what he's getting at.
That's the core of it.
Lake argues that certain narratives, even ones that start from a place of genuine concern, get weaponized. They become instruments of social control, and they effectively silence dissent and just eliminate any necessary legal scrutiny. So our mission today is to really analyze the mechanics of his critique. How does emotion, how does social panic override due process, and how does that lead directly to this crisis of wrongful convictions that we see playing out in the data?
And we have to approach this with precision, because that's what Lake does. He's obsessed with incentives and mechanics. He forces us, and you, the listener, to confront a really difficult question. Is the justice system, and that includes the media, political bodies, community outrage, is it truly incentivized to find the objective truth?
Yeah.
Or is it just incentivized to look decisive, look effective, and look moral? That distinction, Lake argues, that is the difference between protection and policing.
And that distinction drives his entire thesis, doesn't it? Because if the system is optimized for optics, then the rule of law is inherently compromised.
It has to be.
So we need to understand not just what Lake argues, but the specific, really uncomfortable implications of his perspective for the future of impartial justice. Okay, so let's start with what's maybe Lake's most widely discussed and, frankly, unsettling claim. It's about the weaponization of language. He focuses on one phrase in particular for the children, and he has this really memorable way of putting it. He calls it a sound effect for panic.
It's a powerful image.
It is. He argues it's systematically used by institutions, by the media, to generate hysteria and to justify some pretty intense social or legal overreach.
And what's so fascinating here and so crucial to his argument is that he goes out of his way to acknowledge the initial concern is absolutely legitimate.
Of course. I mean, who doesn't want to protect children?
Right. It's a universal moral imperative. No one disagrees. But he says the moment that legitimate concern is deployed as an argumentative shield, that's when the framing transforms.
Into what he calls a moral cudgel.
Exactly. That transition from a noble goal to a rhetorical tool.
Yeah.
That's the mechanism of weaponization he's talking about.
So what effect does that mechanism have on the system? I mean, how does this cudgel actually operate in practice?
Well, when that phrase is used successfully, it immediately creates this binary, non-negotiable moral space.
Either you're for the children or you're against them.
Precisely. And people feel this immediate, overwhelming social and political obligation to act on mere suspicion. Sometimes not even suspicion, just rumor.
And they actively resist the very things designed to prevent error.
Yes. The procedural safeguards that are designed to require proof. Lake emphasizes that once that trigger is pulled, all these critical legal principles, nuance, due process, proportionality, the need for concrete evidence, they just vanish from the conversation.
They're not seen as necessary parts of justice anymore.
No, they're seen as obstructions to protection. They're getting in the way.
So we're really talking about a fundamental shift in purpose for the children. Stops being this worthy goal, protecting actual kids from actual harm, and it becomes a tool for moral policing,
Right.
where the real objective is just managing public fear and showing how righteous your institution is.
That is precisely his point. And Lake notes, history is full of versions of this. This isn't a new phenomenon.
Yeah.
Whether it's 17th century witch trials or 20th century censorship campaigns targeting books and movies, or even modern moral panics that result in massive legal overreach.
We were all justified the same way.
All of them. By appealing to this urgent existential need to protect innocent victims. The victim population is real, but the hysteria that results. He argues it often creates more collateral damage, more social fracture, and frankly, more injustice than the actual threat being addressed.
The goal shifts from effective policy to just symbolic action.
It becomes a performance.
And if that symbolic action, that virtue signaling, is clearly taking priority over finding the truth, this is where Lake says arguing about terms like witch hunt is just a waste of time.
Absolutely. The defining characteristic of a moral panic, in Lake's view, it isn't about the legal status of an investigation. It's about the societal and institutional incentives.
So what's driving the machine?
Exactly. If the system is prioritizing the appearance of caring over the execution of evidence-based protection, the entire exercise is already a failure of justice. He says the witch hunt isn't a legal term, it's a structural condition where societal compliance is valued more than due process.
Okay, this is where it gets really interesting for me, because Lake doesn't just diagnose the problem, he gives us key indicators. He tells us definitively when virtue signaling has taken over from the search for truth.
Right.
This is the structural failure he wants us to be able to recognize.
He lays out 4 stark, observable indicators that the system has sacrificed reality for optics.
Let's break those down. The first indicator he mentions is that evidence becomes optional. What does that actually look like on the ground for, say, an investigator or a prosecutor?
It means the standard of proof isn't just lowered, it's functionally removed. It's replaced by belief or by emotional conviction.
A gut feeling.
A gut feeling. And in practice, this leads to confirmation bias, to tunnel vision in investigations. Why would you bother trying to corroborate a challenging fact? Or why would you even follow up on a lead that might exonerate someone if doing that undermines the narrative the public and the media are already demanding?
It'd be going against the tide.
You would. Lake argues that the bar is set so low that belief, just the feeling that someone must be guilty, is treated as enough. And that allows faulty testimony, false confessions, junk science to just walk right into the courtroom unchallenged.
Which leads directly to his second indicator. Suspicion is immediately treated as fact. I mean, that sounds like the total destruction of the presumption of innocence.
It is. The process of verification, which is supposed to be the central pillar of a constitutional system, it's immediately seen as an obstruction.
It's a nuisance.
It's a nuisance. If the goal is rapid signaling showing the public that action is being taken, then any defense, any request for discovery, any critical questioning of an accuser is immediately framed as protecting the accused.
And therefore opposing the victim.
And therefore you're on the wrong side. Lake warns that this effectively transforms the legal process into an administrative hurdle. The punishment starts the moment the accusation is made. The trial just decides for how long.
Wow. Okay. The third indicator is about public validation. Public perception matters more than the actual truth of the matter.
This one is all about institutional survival. If the public, spurred on by that moral cudgel, believes justice was done, if they feel reassured that the institution or the political body responded decisively,
it's a win.
The system considers it a win, regardless of whether the person convicted was actually guilty.
And Lake points out that the modern ecosystem of social media, digital outrage, clickbait media, it's perfectly aligned with this.
It's the perfect engine for it. Certainty and speed get rewarded. A measured, slow pursuit of the truth gets punished by public outcry.
And the final, and I think most chilling indicator, is that people are punished for optics, not for their actions.
Right.
It stops being about real accountability for a proven crime, and it starts being about managing the political or social look of the situation.
Exactly. When an institution fires an accused person immediately, before any evidence is assessed, before a legal finding is made, that's punishment for optics.
The institution is protecting itself.
The institution is saying, our reputation requires us to look responsive, and your actual guilt or innocence is secondary to managing this perception. Lake insists this whole process is inherently about social control. It's not justice. The fight shifts completely from stopping genuine abuse to looking like you're stopping abuse.
And he has that really powerful analogy for why debating the legal definition of a witch hunt is useless when you're facing this kind of structural failure.
He does. He says trying to debate the legal definition of witch hunt while the system is prioritizing certainty over evidence. It's like trying to debate the definition of speeding while the car is already barreling off a cliff.
The trajectory is all that matters.
The dangerous trajectory of the justice system, where reputation outweighs evidence, is the only thing that matters. The structural failure of the whole structure of incentives makes the unfair outcome predictable. The system is designed to comply with public outrage, and that, he concludes, makes the resulting injustice inevitable.
And that systemic failure leads us right into Lake's next critique, which is about how, in practice, emotion replaces evidence. And he's specifically looking at decades-old accusations. He asks us to confront this dramatic but frighteningly common scenario. He says, imagine a system where a single accusation, decades old, based solely on memory, can reshape someone's entire life.
And this is where Lake really pushes on the constitutional line. He highlights these really challenging cases where there is often no DNA, no documents, no corroborating evidence, just words and memories stretched thin by time. And yet, society allows this lack of foundational objective proof to be treated as enough to strip away someone's dignity, their rights, their liberty. This isn't about dismissing how hard it is to prove old crimes. It's about defining the line between an accusation and the legal condemnation.
The core question that Lake raises here, and it really cuts to the heart of constitutional principles, is this. How did society allow itself to be guided more by anger and suspicion than by the cold, rational requirements of reason in the Constitution?
He's drawing a very clear line between two distinct concepts here: moral certainty and constitutional proof.
They are not the same thing.
Not even close. It's one thing to feel morally certain that someone is guilty based on a compelling narrative. It is something else entirely to meet the high burden of proof, beyond a reasonable doubt, that the U.S. Constitution requires for legal punishment.
And his warning is?
His warning is powerful. It said if we surrender fairness and the presumption of innocence in the name of outrage, then no one, regardless of how safe or innocent you feel today, is safe from the machinery we claim as righteous.
So the moment we let subjective certainty replace objective evidence, we're basically building a machine that can be aimed at anyone?
Precisely. And he summarizes that principle by stating, punishment without proof is not justice, it is spectacle.
And to cheer for that spectacle.
To demand it is to become complicit in a profound moral and constitutional failure. He argues that this demand for absolute moral certainty often serves as a dangerous shortcut, bypassing the very difficulty of getting evidence that's supposed to protect the innocent.
Okay, now, Lake's analysis gets even more challenging here and probably more controversial when he brings in the complex issue of adult agency and retrospective interpretation.
Right. This is a tough section.
It is. This is where he makes a crucial distinction that forces us to analyze the situation purely through the lens of evidence versus feeling.
And his position is explicitly based on legal requirements. Justice, he says, must be fundamentally built on evidence, not subjective interpretations of past experiences.
Even if those experiences are real.
Even if they are. Those past experiences, whether they involve regret, trauma, or dissatisfaction years down the line, they are legitimate sources of pain and personal truth. But Lake argues they cannot, on their own, serve as a proxy for factual evidence in a legal proceeding.
Can you tell me more about why Lake insists this blurs the line between empathy and judgment?
He argues that to introduce intense, legitimate personal feelings as the sole proxy for factual evidence, it just creates an unacceptable risk. It risks punishing someone not for a crime that can be proven, but for choices the accuser made, or for consequences that the accused didn't necessarily control or foresee.
So he's not minimizing the trauma.
No, he's not minimizing trauma at all. He's emphasizing that the legal system is designed to determine criminal culpability, and that requires objective evidence of the defendant's actions and state of mind at the time. When emotion replaces evidence, judgment gets clouded by empathy, and the defendant's due process rights become virtually impossible to uphold.
Let's break down the specific examples Lake uses to illustrate this really complex distinction. First, the issue of retrospective reinterpretation.
This is a cornerstone of his critique here. Lake emphasizes that if two adults engaged in an encounter that was, by all evidence available at the time, consensual, deciding years later that the event is now framed as a violation cannot, on its own, justify punishment without clear, corroborating evidence of coercion or violation at the time of the event.
So the accused, in that scenario, is being judged retroactively.
They're being judged for a story that's being told in a contemporary context that suits the accuser's current feelings or, the political moment, not for a proven act of criminality that happened in the past. If we allow subsequent regret to become evidence of an initial crime, the whole standard of consent becomes fundamentally unstable.
And he's also really firm on the role of financial or professional relationships. He states that accepting money, contracts, or career opportunities can't in itself prove another person's guilt.
Correct. Lake argues that these are personal decisions. They're reflections of one's own values or compromises or professional choices, but they cannot be confused with culpability or evidence that a crime, like sexual assault or fraud, actually occurred.
He's warning against conflating opportunism with criminality.
That's the perfect way to put it. Just because someone feels they made a bad professional choice or that they were exploited years ago in some power dynamic, Lake insists that should not automatically be used as proof that a crime took place. It blurs a moral or personal judgment with a factual criminal one.
So the system has to find proof of the crime itself.
Yes, regardless of an unequal power dynamic or the accuser's later feelings of regret.
So Lake concludes that when personal narrative dictates legal or social condemnation, when justice becomes a spectacle or performance, the whole focus shifts.
The accused is judged based on a revised narrative, told at a time and in a context that suits the accuser, often long after the accused has any meaningful chance to defend themselves with contemporary evidence. He calls this moral theater.
And the real danger is the precedent.
That's the danger. It punishes the defendant for a story told at a distance, rather than for a proven fact. This is just an open invitation for systemic error.
And that normalization of narrative over proof is what Lake sees as the true threat, because it doesn't just stay confined to one specific area of law.
No, it bleeds over everywhere.
And he provides this striking political example to show how this dangerous precedent works, even outside the formal legal system. He mentions how President Trump publicly attributed the murder of Rob Reiner's relative to Trump derangement syndrome, without any proof contradicting the known facts.
Lake's use of that example is critical because it's nonpartisan, and it's clearly outside a courtroom, but it highlights the societal corrosion. The point is about the logic that's being normalized across the entire social hierarchy.
Right.
If a narrative can be imposed immediately, emotionally, and without evidence by even the most powerful figures in the country, then that logic prioritizing political certainty over factual proof has already been absorbed into the cultural subconscious.
So if the political culture accepts that an emotionally satisfying story is a substitute for evidence in public condemnation,
Then the justice system, which exists inside that culture, will inevitably reflect that impulse instead of resisting it.
exactly. Lake argues that the legal system is not immune to these prevailing social pressures. Once certainty replaces evidence at the top of the social hierarchy, in media, in politics, in social debate, the justice system just reflects that by lowering its own standards for evidence.
And the consequence isn't just social damage, it's the destruction of constitutional due process, which, as we're about to see, has devastating empirical costs. So Lake's arguments, which can sound theoretical, almost philosophical, we have to connect them now to the concrete data from the U.S. criminal justice system.
Because the data is the evidence for his whole critique.
It's the irrefutable evidence that lowering the evidentiary bar and prioritizing optics inevitably leads to massive, widespread unfairness.
And we have astonishingly clear numbers from David Kim's report on the nearly 150 exonerations recorded in 24 by the National Registry of Exonerations. I mean, this data is the empirical proof of what Lake calls process rot.
Let's just spend a moment and absorb the sheer scale of the failure documented in that single year. The registry documented 147 prisoners exonerated in 2024 alone.
147 people.
And these individuals collectively lost nearly 2,000 years of their lives to wrongful imprisonment.
2,000 years.
That averages out to 13 and a half years per person. Just imagine giving up 13 or more years of your liberty, your career, your family, because the system decided a narrative mattered more than proof.
The human cost is just immeasurable. But the financial toll? That also speaks volumes about the systemic failure.
It does.
We're talking about compensation for exonerees through state payments or civil awards. That has surpassed $4.6 billion since 1989.
And to put that into perspective for you, that money is completely separate from the immeasurable trauma inflicted on these individuals and their families. It is a direct accounting of decades of failed and often corrupt prosecution.
And if we look at the types of cases overturned, homicide dominated the year's exonerations. It accounted for 58% of the total.
That's 85 cases, 81 of which were murders. These are the highest stakes cases our system handles.
We also saw 9 sexual assault cases overturned, and, tragically, 4 of the exonerated individuals had faced or served under a death sentence.
Meaning they were within the closest proximity to irreversible state-sanctioned murder.
So now let's deep dive into the specific systemic failures exposed, because this is the data that directly validates Lake's concerns about corruption and prioritizing compliance over truth. The number that just leaps off the page is official misconduct.
It is the defining feature of this data. Official misconduct was identified as the single most pervasive contributing factor. It tainted 71% of all 2024 exonerations.
71%, that's 104 cases.
And we have to be clear, this isn't just about sloppy paperwork. This is deliberate corruption of the process by institutional actors.
And the numbers are even worse in the highest stakes cases, which proves Lake's point that pressure just makes error worse.
It does. In homicide cases, the official misconduct figure jumps to 79%. Meaning 67 out of 85 murder exonerations were marred by official misconduct. When the pressure to get a conviction is at its highest, the integrity of the process drops to its lowest.
And we should clarify for you, the listener, what do we mean? What does the registry mean by official misconduct?
It covers a devastating range of deliberate actions by people in power. This includes withholding exculpatory evidence, what are known as Brady violations. It includes witness tampering, manufacturing evidence, or, critically, outright perjury committed by law enforcement or prosecutors.
We see a devastating illustration of this in the case of Sandra Hemme. She was exonerated in Missouri after 43 years.
43 years. The longest wrongful imprisonment for a woman in U.S. history.
And her case is a textbook example of the kind of systemic rot Lake describes.
It is. Her conviction relied heavily on a false confession she gave while she was heavily medicated and in a state of mental distress. But the crucial element of misconduct was that the prosecutors failed to disclose evidence that would have fundamentally undermined her false confession.
And pointed to the real suspect.
And pointed toward the actual suspect, who was a local police officer. The system secured the conviction by suppressing the truth.
And this wasn't an isolated incident. The report reminds us of the judicial outrage in the Carrie Max Cook case, where the Texas Court of Criminal Appeals just explicitly chastised the system.
Yes, stating that several actions of the state go beyond gross negligence and reach into the realm of intentional deception against the tribunal.
Intentional deception, those are not just administrative errors.
No, those are deliberate actions that illustrate Lake's worst fear. That investigators and prosecutors, under the pressure of public opinion or career advancement, they stop corroborating evidence and they start complying with a predetermined narrative of guilt.
They become agents of conviction.
Not agents of truth.
And these process errors, they rarely happen in isolation, do they?
Yeah.
The report highlights how these factors are often intertwined, creating this complex, sometimes insurmountable web of injustice.
That's right. What were the other major factors contributing to the exonerations in 2024?
Well, beyond official misconduct, which was really the foundational problem, we saw perjury or false accusations present in 72% of cases.
72%.
False or misleading forensic evidence, either through genuine error or, willful misrepresentation, that was a factor in 29%. Mistaken witness IDs, often tainted by suggestive police lineups, contributed to 26%.
And importantly, what about legal counsel?
Ineffective legal counsel played a role in 33% of the cases.
So that shows a profound failure at nearly every single stage of the process.
It does. Tell me about Charlotte Platez, who's mentioned in the sources. Her case really highlights that fatal intersection of errors.
Platez, who was exonerated in California, was convicted based on a mistaken witness identification, which, when combined with other failures, led to her wrongful conviction.
And it was disproven later.
Yes, later disproven by DNA evidence and forensic work that pointed to the actual perpetrators. Or you can consider Gilbert Merritt III, convicted solely on the coerced false testimony of an acquaintance testimony that was orchestrated by a detective who was later convicted of perjury himself.
So when the people running the system are fundamentally corrupt, the whole foundation just collapses.
It has to.
The most shocking categories for me, though, are the no crime and the group exonerations, because they fully reveal a system that's just detached from reality, chasing convictions where no crime even occurred.
A shocking 35% of all exonerations, that's 51 cases. involved convictions where no offense had happened at all.
That statistic is the purest evidence that the system is optimized for compliance, not for competence.
It is. These no-crime cases included basic failures, like drug possession cases where the substances were later confirmed not to be illegal narcotics, or fabricated evidence used to secure confessions.
And even deeply disturbing cases.
Yes, cases tied to murder and child sex abuse, where the underlying crime, the death or the abuse, simply did not happen. This confirms Lake's argument. A system driven by panic doesn't catch more real offenders. It just catches more people, guilty or innocent, to satisfy the public's demand for certainty.
And the group exonerations, they illustrate this widespread, almost industrial-scale corruption that Lake suggests is inevitable when that process rot sets in.
Indeed. Two specific group cases added in 2024 involved 54 individuals.
Yeah.
54. And they illustrate how systematic misconduct by rogue officials can corrupt entire precincts, entire judicial systems.
And these cases largely came from
The actions of former narcotics officer Gerald Goines in Texas and Ronald Watts in Chicago. These officers used their authority to plant drugs, falsify reports, and coerce testimony, generating dozens of false convictions based on their systematic dishonesty.
And we see that geographical concentration so clearly reflected in the data. Texas led with 26 exonerations, largely linked to Goines' misconduct.
And Illinois recorded 20, often reflecting the legacy of prior police misconduct in Chicago.
That jurisdictional concentration is telling, isn't it? Because it reflects two things at once.
It does. First, the historical depth of corruption in those areas, and second, the presence of active oversight bodies, like conviction integrity units or CIUs, that are committed to exposing and correcting past wrongs. Without that dedication to oversight, those 54 people in the group exonerations would likely still be in prison.
Which brings us to the indispensable role of those oversight bodies. Lake's argument implicitly calls for stronger checks and balances, and this data provides a powerful argument for them.
It's a huge argument for them. Innocence organizations, IOs, and conviction integrity units, CIUs, they contributed to a massive 63% of 2024's exonerations.
63%, so two-thirds.
This point cannot be overstated. The long-term trend is undeniable. The rise in exonerations we're documenting year after year is tied directly to the growth of these professional advocacy and review groups.
So without them?
Without IOs and CIUs reviewing the evidence, coordinating with defense counsel, and pushing back against institutional inertia, many two-thirds, based on this data of these injustices, would remain hidden, buried under the weight of a conviction. Lake's point is proven by their very existence. If the system was inherently just and self-correcting, we wouldn't need these dedicated external groups to correct two-thirds of the documented failures every year.
The system, left to its own devices, prefers conviction to correction.
Absolutely.
Okay, let's return to Lake's core argument about how the system actively discourages the pursuit of truth, and let's link it directly to the terrifying personal toll we see in this exoneration data.
Right.
These 147 cases and the 2,000 lost years are precisely the kinds of cases that illustrate how a justice system supposed to be grounded in proof and due process can fail when emotion, pressure, or narrative outweighs evidence.
And that failure is baked right into the rules of the game, particularly through sentencing laws. Lake provides this really detailed analysis of what he calls the brutal calculus imposed by the specter of mandatory minimum sentencing.
This is the mechanism of coercion he talks about.
It is.
So explain that trap he sees. How do mandatory minimums rig the system against the accused, even the innocent ones?
The choice presented to defendants is often completely rigged. It's grossly asymmetrical. If the defendant is innocent and chooses to fight the charge at trial, they face this catastrophic risk of devastating mandatory minimum sentences. We're talking 60 years or more if they're found guilty.
So the state leverages that fear.
Completely. The rational choice, even for an innocent person, is often to just waive their rights, take a plea deal, admit guilt for a crime they may not have committed, and just preserve some hope of one day being released.
The mandatory minimum turns the trial itself into a threat.
It turns it into a mechanism of coercion rather than a truth-seeking exercise.
Which means the system wins twice when an innocent person takes a plea.
The first win is immediate. The system gets a conviction without having to present real, verifiable evidence in a trial. The fear of the mandatory sentence is the evidence.
And the second win.
The second win is insidious. It conditions everyone else in society, the media, the public, other defendants, to believe that the accusation and the plea are proof of guilt. further validating this compromise system.
So plea bargaining, under the shadow of these draconian mandatory minimums, systematically bypasses the constitutional protections.
The very protections that were supposed to be the bedrock of our justice system.
We have to reflect on the specific, catastrophic consequences of this failure. The human victims of this process rot. We already mentioned Sandra Hemi, who lost 43 years.
And the case of Carrie Max Cook, whose ordeal began all the way back in 1978. He spent close to 15 years on death row because of what that Texas court later exposed as a web of fabricated testimony and misrepresentations.
Think about the sheer endurance required for that.
It's almost unimaginable. Even after he secured a conditional release in 1999 based on DNA evidence that wasn't used correctly the first time, Cook had to fight for another 25 years just to clear his name fully. He finally achieved that in June of 2024.
That decades-long struggle is proof of what Lake is saying.
It's proof that the system is virtually incapable of undoing its own mistakes without massive external pressure.
And we can't forget historical examples like Anthony Porter, who was mere days away from being executed before new evidence came out and cleared him.
Those cases aren't just statistics of time lost. They are living proof that convictions secured under moral pressure or through misconduct move dangerously close to irreversible harm. They validate Lake's central premise that convictions without robust, verifiable evidence aren't exceptional occurrences. They are a predictable outcome of a system prioritizing speed, compliance, and narrative.
And Lake brings all of this together by summarizing the predictable sequence of consequences that happens when a society suspends skepticism and allows narrative and moral certainty to overpower due process. He offers 4 clear predictions about what inevitably follows.
First, he warns that false positives explode. Lake states that any justice system that lowers its evidentiary bar or allows belief to stand in for fact doesn't just catch more real offenders, it drastically increases the number of innocent people it catches.
Which is exactly what that 35% no-crime rate in the 2024 exoneration data demonstrates.
Exactly. Accusations fueled by grudges, misremembered events, financial incentives, or just honest human error all become deadly weapons, masquerading as justice.
Okay, second, he predicts a process rot sets in.
And this is the 71% official misconduct data in action. Investigators stop investigating, prosecutors stop corroborating, forensic teams fall prey to confirmation bias, and juries are subtly or sometimes overtly asked to send a message or comply with the community's moral demands rather than weigh facts impartially.
The verdict becomes a signal of compliance.
It signals institutional compliance with the moral panic, not genuine confidence in the truth. The whole process is contaminated right from the start.
Third, Lake warns that power asymmetry becomes predatory.
He argues that once rights can be bypassed in the name of virtue, when we say we must secure this conviction for the children or for the victims, anyone with institutional backing, public sympathy, or political leverage gains overwhelming power over the accused, who are often just ordinary people without resources or influence.
The system stops protecting the vulnerable against the state.
And starts rewarding whoever controls the most compelling narrative. Ordinary citizens, stripped of their due process rights, just become collateral damage in the war against some abstract moral evil.
And finally, his 4th prediction is that exonerations pile up slowly, painfully, and too late.
He argues the history is clear on this. Every era that embraced moral panic over due process eventually produced waves of overturned convictions. This doesn't happen because society suddenly grows a conscience. It happens because the foundational evidence for a legitimate conviction was never there in the first place, and eventually the truth just leaks out.
And Lake concludes.
He concludes, this one will be no different, just messier.
And that messiness is compounded exponentially by our modern digital environment, a point Lake returns to constantly.
He notes that digital outrage and permanent records mean the punishment now outlives the sentence. Even if a wrongful conviction is overturned 40 years later, the reputational harm, the social stigma, the digital footprint of that initial accusation and condemnation, they're often permanent.
His final definitive statement ties right back to the initial moral critique of the entire system. He warns, a society that teaches itself to accept punishment without proof does not stay selective about who deserves it. Once fairness becomes optional, it is simply gone.
And what replaces justice, he argues, is a ritual of reassurance, where destroying the accused makes observers feel virtuous, safe, and absolved.
And Lake is absolutely adamant that this process is not true protection.
No. He says it is sacrificing the rule of law to manage fear. Outro.
So, to synthesize the key takeaway from Justin Lake's rigorous analysis, he really compels us to shift our focus from the outcome to the process.
Right.
We have to constantly question the underlying incentives of the justice system and, by extension, the whole social machine that feeds it. Are we truly measuring truth, or are we measuring compliance?
And we connect that to the bigger picture.
The 2024 exoneration data, specifically that 71% rate of official misconduct, it proves that systems driven by narrative over proof inevitably manufacture victims on both sides of the courtroom.
Lake forces us to confront the core dilemma of modern justice. Justice is not convenience, nor is it just about satisfying the loudest public demand. It is a standard, impartial evaluation of objective facts, evidence, and guaranteed due process.
Anything less. Anything less. Anything that substitutes moral shorthand or emotional certainty for proof is merely an illusion of justice. For you, the listener, understanding Lake's work means recognizing the critical difference between feeling righteous and being factually correct.
Indeed. We've seen it through the analysis of Lake's work and the stark exoneration data. Official misconduct is the single greatest threat to justice today. It's not poor training, it's intentional contamination of the process, proving Lake's theory that institutional actors will comply with a high-pressure narrative even if it means sacrificing the truth.
So what does this all mean for you, navigating a world that's just steeped in digital outrage? It means recognizing that the constitutional protections we often take for granted are demonstrably prone to error and deliberate abuse when the principles of due process are eroded by fear or political pressure.
It's a fragile system.
It is. Lake argues that digital outrage and permanent records mean the punishment now outlives the sentence. So if the public hunger for spectacle and certainty guarantees misconduct, as the data shows, what single change, large or small, could you make in your own decision-making in how you consume information or participate in public condemnation to fundamentally resist that siren call of moral certainty until the facts are fully and impartially established? It's a question worth mulling over.